I got. She previously pled not guilty to both the charges. I spoke with her and she wants to continue with her not guilty plea.
Oh, okay. Then we just get to go ahead.
I don't know if she got the offer was for her to plead to the ONR and I would dismiss the petty larceny just so she's aware, but if she wants to plead not guilty, that's totally fine.
Okay. All right, Miss Major, are you there?
Yes.
What is your plea to both? What's your plea to the obstructing and resisting?
Well, you just gave me a deal, right?
No. This is a deal. This is when you enter your plea. I need to know what your plea is to this charge.
Not
right
guilty.
Right now, there's no plea. Okay. The obstructing and resisting, you're pleading not guilty?
Yes.
Okay. And the petty larceny, you're pleading not guilty?
Yes.
Okay. Ladies on bail?
So I think she is in custody because she failed to appear, if I'm not correct. Bail is currently set at $500 bondable. I think that's pretty low.
No, I went to the court date and they sentenced me to domestic violence classes. So that's why I'm saying if I could please be released today.
I think we're dealing with something else here. Ms. Mayhew, what's your thoughts on bail?
Your Honor, I do believe I wrote down 1,000 bondable. Obviously she can't make, I think that's already been implemented. She can't make that. So I'd submit it to the court on whether or not you think it's appropriate to modify that.
All right, Miss Portia Major, I'm going to give you a Solomon wisdom. It's going to be $750 bondable, pending your trial. Your pre-trial conditions, young lady, obey all laws and no drugs and alcohol. That will be the order. And put an application in, talk to the jail, put an application in for a legal defender, okay?
Judge?
Yeah.
She was already previously set for a trial with Department 4, and it's set for October 23rd at 8 a.m.
Okay. All right.
Okay. I see that she's a community court candidate, possibly. So she may want to think about, doing down the road.
Yeah. Okay. That'll be the bail. That will be the date, young lady. And put an application in for a legal defender. The jail has that information. Thank you very much.
Okay. Will I be released today?
No. If you make the bail, you will. Okay. Let's go to Tyler Gruber, Gruber.
Thank you. Have a good day. You're welcome. What we'll call the matters of Jonathan McGalley, 18W00648. 19W008901, 19W010101.
Paul Barnett on behalf of the township.
Hello, Mr. McGalley. I think you don't have counsel on this. Please state your name, sir.
Jonathan McGoy.
Mr. Goy.
Good morning.
Good morning. I thought you were supposed to be, didn't I see you last time in custody? Yes. I thought you were getting out.
I did too.
Oh. What are you being held on?
I don't know. They just don't. I think they like having my presence here. I think I make them feel better. So they use me for counseling now.
What case are you being held on, sir?
I think my lawyer told me not to talk about
it. Okay.
Yeah.
All right. So when do you think you're getting out?
So,
sir, a date, please.
Let's say November. October. Yeah, like November.
Okay. You're here for fines, for payment of fines and costs and some civil infractions, for which I can't give you jail time. Otherwise, I would just get these matters resolved.
I'm sorry, I would. You know how much I love giving you my money.
You're in rare form again today, huh? All right. I guess I'll see you back here on December 13th, see how things are going, okay?
December 13th?
Yes, sir.
All right.
At 10 o'clock. Thank you.
Thank you.
Bye. Have a good day.
So,
the court will call the case of Jewel Mackey, 23T11811.
Paul Barnett on behalf of the township.
There you go. Come on, man. Okay. Hello. Good morning.
Hello, Mr. Mackey. Good morning. Could you please state your name for us?
Randy Mackey.
Are you Randy Mackey or Jewel Mackey?
Well, that was my mother. She died 3 months ago. I got the ticket just before she died. It was her car and my car, and we just bought a new one a couple of years ago, and that was part of my work. But they said because a couple tires went flat on them, that I had to remove them, and I couldn't get out and do anything. It took me a while because my mother was dying. I had to stay right by her side.
I'm sorry to hear that, Mr. Mackey. One moment, please. Mr. Barnett?
This is Mr. Kelch's case, and I spoke with him earlier, and he said that Mr. Mackey is now in compliance with the township ordinance, so I'm moving to dismiss the ticket.
All right, your ticket is dismissed, Mr. Mackey. You're all set. You can go home, okay?
Okay, thank you, and God bless.
Thank you.
He said he would take care of it, so. All right.
Defendant Chinazikari, I can really on behalf of Mr. Edward Johnson. Mr. Johnson, could you state your name for the record, please?
Edward Johnson.
Thank you. Have we come to a resolution as to the fix for the testing?
Yes, Your Honor. Mr. Johnson would like to try the SoberLink device. He did say that charging might be an issue, but I told him that he would be able to speak with community corrections and they'll give him all the information he needs.
All right. No objection by you, Mr. Barnett? Correct?
Oh, no, that's fine.
SoberLink will be ordered in replace of the testing.
Thank you, Your Honor.
Thank you.
And Your Honor, one I hate this experience, but one good experience I did get out of this, I did get one thing out of it. Meeting you, Judge Washington, I appreciate you, prosecutor, and my attorney, she's awesome too, man. I appreciate y'all.
Mm-hmm. Thank you,
I appreciate y'all. It means a lot to me. It inspires me. It's not a bum, but y'all help me out. Appreciate y'all.
Thank you, Mr. Johnson.
I'm proud of y'all too.
Thank you. Take care of yourself,
you.
Mr. Johnson.
No, thank you so much. All right, bye.
Bye-bye. The court will call the Joe Cole matters 23T12303, 23T10968, 23T10975, 23T12871, 23T12872.
Paul Barnett on behalf of the township.
Actually, the only one that's on is 23T12303. The rest of them have been defaulted. Yes, Mr. Cole, how are you? Please state your name.
Oh, my name is Joe Cole.
Thank you. So, Mr. Cole, you only really have one ticket on before the court today. That's the 23T12303. They haven't shown up to this court on June 28th, August 2nd, June 21st, July 21st for 2 tickets. We have 4 defaulted tickets, and now this ticket.
Yeah, Your Honor. I'm number one. I'm not real familiar with Zoom, and a lot of times the tenant. Pardon me.
Mr. Cole.
Yes.
You and I have a little history. I think you're pretty familiar with Zoom.
No. That's why I say that. I'm not. Somebody had me on there when I was doing it. I didn't do it myself, but anyway, yeah, I have been on here before. I have. I'm sorry, but I just couldn't. I was trying all morning to get the audio on, and I finally, I got help from your office, but I got that done. But and catching up with the tenants.
Well, before we get into the substance of the case, 1 second, Mr. Burnett.
Okay.
So, Your Honor, this was, I think, a week or so ago. Mr. Cole defaulted, but he showed up after Ms. Regala had already left the docket, and so I think you set aside the default.
I did.
Giving him more time to bring the property into compliance. The issue is that it's not certification as a rental has not been completed, and I think there was a permit that needed to be pulled for the furnace that didn't happen. And those things never happened. This is a second offense. I don't really have anything to offer Mr. Cole. He can admit responsibility and pay the fine.
So the fine in this case would be $500. You're entitled to have a hearing, Mr. Cole, to see if you are in compliance or not in compliance. But at this point,
I do, Your Honor, I do have a.
Can I finish? Can I finish?
I'm sorry. Okay, I'm sorry.
But at this time, the prosecutor is not making any offer. So, are you requesting your hearing, or because you seem to be trying to tell me about a certificate you have? So it's the prosecutor's burden of proof to show that you don't have a certificate. But then he also says you haven't pulled some permit. So there are two prongs to his rental property violation that he has here. One is that you don't have the certificate to rent. And then the second one is that there's some type of a violation of a permit. So, valid certification. Do you want a hearing today, sir?
Yes.
Mm-hmm.
Yes.
Okay. Then the hearing is what we're having. Are you ready to go, Mr. Burnett?
Sure. Yeah.
Before we do that, what's Mr. Gooden here on? If I can let him go.
He's got Kevin Hickey, Your Honor.
The court will call. 1 second, I'm going to pass your matter. I'll be right back to you, Mr. Cole.
All right.
Court will call the case of Kevin Hickey, 23T13776.
Paul Barnett on behalf of the township. We're here for formal hearing. Mr. Hickey has not appeared on the Zoom. We're asking for entry of the default with the fine of $100 plus entry of an order, which would allow the township to enter the property and
I don't really loan money like that.
Compliance and start that expense back to Mr. Hickey.
All right, Mr. Gooden, he has not come into compliance. That is your statement today.
The last I checked, he was not in compliance, Your Honor.
When was the last time you checked, Mr. Gooden?
About a week ago.
I'm not really willing to do that unless we've had a recent check, Mr. Barnett. I think we need to check to make sure that he's not compliant.
Fair enough, Your Honor. All right. So should we procedurally adjourn the matter for a week? And then...
let's adjourn it for a week and then we can have a check.
Okay. And Mr. Gooden, if you could go out there prior, that would be great.
September 20th, 2023 at 10 a.m.
Thank you, Your Honor.
You're welcome. All right. Who's handling the Woodbring matter? Is Ms. Carpone still here?
She is not, but I can handle that without her.
Okay. Ypsilanti Township versus Shane Woodbring. Case numbers 23T11567 and 566.
Paul Barnett on behalf of the township. Your Honor, this was Ms. Carcone's case. It's up for formal hearing. It's my understanding that the property is now in compliance, so I'm moving to dismiss both tickets.
All right, thank you. All right, now we can go back to Mr. Cole's case and take testimony. Recalling the case of Ypsilanti Township versus Joe Cole, 23T12303.
Paul Barnett on behalf of the township.
Mr. Joe Cole, please unmute again for us, please. What's Dr. Turner here? Who is that?
He's not gotten into response to me at all yet, and they're not connected to audio.
Okay. Mr. Joe Cole, please unmute your device and state your name. You're still muted. You have to push the button.
Okay, can you hear me?
Yes. Please.
My name is Joe Cole. What are you requiring me to do?
Just state your name for right now.
Okay, Joe Cole.
Thank you. All right. At this point in time, it is my understanding we're having a hearing in this matter. I'm going to swear in Ms. Rogala and Mr. Cole at the same time. So if you could both please raise your right hands. Do you swear or affirm that the testimony you're about to provide will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
I do.
Thank you. Mr. Barnett, your witness.
Thank you. I'm calling Ms. Rogala. Ma'am, would you state your name for the and spell it, please, for the record?
First name Sandra, Sandra. Last name Rogala, Rogala.
Ma'am, how are you employed?
I'm an ordinance officer for Ypsilanti Township.
And what are your duties as an ordinance officer?
I do rental inspections as well as other ordinance matters for the township.
So you visit various properties throughout Ypsilanti Township to determine if they're in compliance with township ordinances?
That's correct.
Okay. And if you visit a property that you find is not in compliance with the township ordinance, what steps do you take?
Initially make contact or attempt to make contact with the property owner. Issue an NOV would be another option. Follow up. If it's not in compliance, then we issue a ticket at that point.
Okay. And NOV means notice of violation.
I'm sorry, yes.
Okay. And there are ordinances that relate to properties that are used as rental properties registering with the township. Is that correct?
That's correct.
And are you familiar with a property located at 1008 Studebaker?
Yes.
And how is it that you're familiar with that property?
I was originally scheduled to do the rental inspection on that property.
Okay. What's located there?
A single family rental property.
Okay. When were you initially supposed to do the rental inspection?
The initial inspection started on March 6th of 2023.
Okay. And what was the information you had as to the owner of the property?
The owner of the property would be Mr. Cole.
Okay, and that's Joe Cole, who's on the Zoom hearing with us today?
That's correct.
Okay, the record should reflect she's identified Mr. Cole. So what was he required to do under the ordinances?
To correct any violations and also make sure that proof of insurance and that the appliances, mechanical appliances, were in proper condition and properly inspected, and or permits pulled if necessary.
Okay, so what were the specific issues at 1008 Studebaker?
There was a furnace that needed to have a permit pulled. It was newly installed, and they required anytime a new installation permit get pulled through the building department and a final inspection be completed by the building department before we can approve the rental. Okay,
so until that is approved, the furnace was approved by the building department, you couldn't issue a rental certificate?
That is correct.
Okay. And did that ever happen?
No.
What other steps did you take to try to get that to happen?
I've had contact via email with Mr. Cole on several occasions about this being corrected. I have not had any compliance at this point.
Did you have occasion to review the township records from the building department or otherwise with respect to this case recently?
Yes.
In fact, today, did you review those?
That's correct.
And does it show that that permit has been pulled as of today?
No.
Okay. Is there a certificate, a rental certificate that's been issued allowing this to be a rental property? Has that been issued as of today?
No, he's not in compliance.
Okay. Are there any other specific issues related to this property?
Currently, everything else is in compliance until that certificate is issued. It can't be issued until the furnace has been properly inspected and permit pulled.
Okay. And you issued this citation on July 26th of 2023, is that correct?
That's correct.
You listed as a second offense. Was there a prior offense Mr. Cole had been responsible for?
Yes.
You know the date of that offense or no?
Give me just a second. On 6/1/2023, the original ticket for the same renting without a valid certificate was issued.
Okay. And how did you know that this was a rental property?
Because I did the rental inspection initially.
Okay. And what do you know when you did the rental inspection?
The original rental inspection was on March 6th, 2023.
I think I asked you that already. Okay.
That's okay.
I don't think I have any other questions.
Mr. Rogala, you say that you know it was a rental property because of that, but do you have any evidence that he's renting this property out?
Yes, I did the follow-up rental inspection on 4/3/2023, and we were partially complied. And then I also checked the records with the assessing department, and it's still active as a rental. It's not 100% PRE, which would be his personal residence.
I don't know how that explains to me that you know that someone is renting the property.
It has not changed property to being a private ownership. It's still listed as a rental property. It's not listed as a vacant property nor a private property.
But do you have any evidence that it's occupied at this time?
To the best of my knowledge, he recently evicted the people out of there, but he's not registered it as a vacant or in any other type of property. At this point, it's still considered a rental.
Mr. Cole?
Yes, Your Honor.
Do you have any questions for Ms. Rogala?
Well, you had handled a case where I was
Mr. Cole?
Yes.
Mr. Cole?
Yes.
My question was really simple. Do you have any questions for Ms. Rogala?
No, I don't, Your Honor.
Okay, thank you. Mr. Barnett, any follow-up based on my question?
Yeah, just very briefly. Ms. Rogala, did you have any conversations with Mr. Cole about how he was using the property?
No additional.
So, okay, so you never spoke with him or emailed with him about what he was using the property for?
No, I just wanted him to be in compliance, told him what was necessary to do so.
Okay, all right, I don't have anything else.
Thank you. Mr. Cole?
Yes.
the prosecutor has rested their case at this time. Is there something you'd like for us to know?
Acknowledge, yes.
I said, is there something you would like for us to know?
Yes.
Okay, now is your time to tell us.
All right. I do have a rental certificate, but to address what she was saying about somebody living there, I've got somebody was basically squatting. You know, I let him come in at first, but then I tried to get him out, and it took from March all the way up until last March until, let me see, I think August or the end of July for him to get out. There were numerous of things going on with him and I, pretty much. I didn't have any contact with him. I couldn't go in because he had the key. Different things came about, but I did end up getting him out, pretty much evicting him. And I did get a rental certificate. Let me see, the date is you see now 8/21. I did go over and I got a rental certificate. $75, and it ended up, the total amount I think was $215.
All right. What address is that rental certificate for, Mr. Cole?
821.
What address is that certificate for, Mr. Cole?
Yes, 1008 Studebaker.
Thank you. Well, I think that you need to be able to provide that documentation to the court and to Mr. Barnett. He's saying he has a rental certificate. Mr. Barnett?
Ms. Regala, do you have any information about that?
I don't show anything on our records for that property.
He seems to have something in his hand. The court would like to see that, at least.
Yeah, because I have outstanding fees.
And then the additional issue is he doesn't appear to be renting the property, just so that everyone is aware. This court did handle a matter that I think he was trying to talk to me about, or testify about earlier, regarding that particular property and the individual, I believe, was evicted. So, I think, Mr. Cole, you need to bring the documentation to the court, and you need to provide a copy to Mr. Barnett.
Okay, where's his office? Or just bring it into the court?
Well, why don't you bring it to Miss? You want to bring it to the court and drop it off to Miss Regala here at Ipsy Township.
Yeah, that makes sense.
Okay.
14B.
Yeah.
Well, you bring it to the court, which is 14B. Miss Regala is in the building that's connected, which is the Ypsilanti Township building, the same place you went to get the certificate from.
Oh, okay. All right.
Okay. So what I'm going to do is continue this hearing until we've had a chance to review that documentation. Mr. Barnett, I'll tell you, I still have some concerns about this particular matter if he's not renting it at this time. He already has, yes, Mr. Gallagher.
It's also not registered as a vacant property. If it's vacant, you're required within 30 days to get that registered as a vacant property if he's not having it listed as a rental.
But I think that would change what his fine would be.
That's correct.
Yeah, that's correct.
Okay. Any time for me to bring it in, or by tomorrow? the end of the week? When should I bring it in?
All right, I'm going to adjourn this matter. Actually, I'm going to adjourn it for 2 weeks to September 27th. Well, I'm going to continue the hearing to September 27th, 2023 at 11 a.m. Bring that documentation in here no later than September.
I wanted to ask you, are you kin to David Tooman?
No, sir.
No.
Bob.
Bob Tooman. Bob. Car dealer. Right? Already? Yeah. Yeah. He and I officiated basketball for a while. Is that your dad? Yeah. So he's a very good guy.
Yeah.
I think I've even caught him. I bought a car for it too one time. It's a while time. Anyway, I heard there was a car wreck on.
Yeah, that's
yeah. Sorry. No. Here's what's happened. I went over everything with these folks, and
Robert Coots on behalf of Mr. Lopez, 433430.
All right. Mr. Rouse on behalf of probation. All right. Can you tell me your name?
Rolando Lopez.
All right, Mr. Lopez, did you see what the allegation against you is?
Yes.
This is the third technical violation. It means you could get up to 15 days in jail. You understand that?
Yes.
And the allegation is that you tested positive for alcohol on 8/24, and then a lab confirmed that. Do you understand that?
Yes.
Okay. Did you go over your probation violation of vice of rights with your attorney?
Yes.
Did you understand those rights?
Yes.
All right. And did you sign and date the back of this form?
Yes, ma'am.
So I have a form indicating you're entering a plea. You understand if you enter a plea, there's not going to be a hearing of any kind. And you'll be waiving the hearing rights outlined in that form.
Yeah.
Sir, to the allegation that you tested positive for alcohol on August 24th, how do you plead?
Guilty.
All right. I'm going to accept the plea as knowing and voluntarily given. Mr. Coots, is there anything you want to say on behalf of your client?
Your Honor, I did on the plea form, I did put a note that we're asking the court to adopt the recommendation from the probation department. But if the court is wanting to impose the 1 day in jail, we'd ask for that to be next week if that's possible. He does have an appointment with a counselor.
You have an appointment today?
Yeah, with my psychiatrist. My first appointment.
How long has he been on probation? Couple months. June 26th. You're not doing yourself any favors, Mr. Lopez.
I understand.
I'm trying to find the order of probation. So he's an ISP.
Yes.
Has he done the substance abuse evaluation?
He just did the mental health.
But not
the, he couldn't do both at the same time.
Okay, so we're waiting on that. Did you do the victims impact panel?
I signed up for it, Your Honor.
Okay. Are you you going to your meetings?
Yes, 2 times a week.
A second reduced down to a first, right? You're looking at all this jail time. You don't have a criminal history other than this. But this should be kind of eye-opening for you, Mr. Lopez, because you're not the kind of guy that gets in trouble, right? You don't have a history of getting in trouble. So the 2 times that you find yourself in a court are because of your drinking. And then while you're in front of a judge who can put you in jail, you're still drinking. That's crazy. I mean, like, as a rational human, you have to stand back for a second and be like, this is wild that I would still do that, knowing that I could go sit in Wayne County for 90 days. Don't you think?
Yeah.
I mean, and you're going to meetings, you're seeing all this, and I'm assuming you think like alcohol's not really, I just did something stupid twice, right? But are you starting to think like, right, you drunk drove twice. Yeah. Lots of people who drunk drive think, well, I made a bad decision, right? I did something dumb. I don't have a problem. Like, alcohol's not affecting my life, even though I've been in the criminal justice system now twice because of it. And now I'm drinking it while I'm on probation, knowing this lady can put me in jail. It's crazy. Something's not working. What's your work schedule?
Right now I'm working I'm self-employed, so I'm doing handy jobs during the week.
What's today, Thursday?
Yeah.
So you turn yourself in tomorrow?
Tomorrow? Yes.
Friday to Saturday, from what time? 10 a.m.?
10 a.m. is fine.
10 a.m. to 10 a.m. on Saturday. All right. Think about that now. Why are you making choices like that? It's troublesome. All right. You're all set.
Thank you, Heather.
Ring, could you please state your name, sir?
Sean Eric Green.
Thank you so much. We're here for sentencing. Have you had an opportunity to review the precedence investigation report with your client?
Yes, I have, Your Honor.
Additions or additions?
Just comment.
Thank you. Ms. McDuffie.
Pardon me, Your Honor. Well, of course, there are some concerns looking at the report with the manner in which it appears that, at least according to probation and the assessor, that there wasn't, I guess, sufficient seriousness taken with that process and with identifying or having insight into what happened. So I'm not sure what the issue is with the drug and alcohol testing results. I understand that this case is obviously an older one, but given that it apparently took so long to resolve, that gives even more of a concern because I'm not really sure what has been happening in the interim. So maybe Mr. Ring and or his attorney can address those, but I echo the concerns of the recommendation at this point.
Sure. I'll do my best to explain what happened here. This case is 8 years old because I appeared with Mr. Ring 8 years ago and addressed this case. And at the preliminary exam, the case was dismissed. It was subsequently refiled, and I'm sure, obviously, this isn't the first time it's happened to you, and it certainly isn't the first time it happened to me. When it's refiled, it's simply thrown into the system, and there's obviously a hold and a lien placed in the system, and the client never finds out about it. Mr. Ring works for a company that was doing some work at the new Washtenaw County Sheriff's Office, and he made an inquiry while he was there. And it was known to him at that time that there was a warrant for this. So he acted very appropriately, contacted my office. I did what I had to do to get him before the court to address this. And when we did appear in front of Judge Simpson and we resolved this matter with the way we resolved it, following that, before the sentence date was set, I asked that Mr. Ring be allowed to go on vacation, which a trip he already planned well before he knew this case was going to resurface. Judge Simpson was kind enough to grant that. And the assessment and probation started calling him while he was on vacation. He did his best to cooperate with them. And as you can see, it's mentioned in there that he was rather flippant. he was actually at an amusement park in Florida with his family, so he was doing the best he could with a difficult situation. He did comply to the best of his ability. And Judge, what I want you to know here is this is a man that this case, not only is it 8 years old, the other matters that are before are 27 years ago and 21 years ago. So with regards to the only issue here with this man is marijuana. He had a medical marijuana card because he has back issues. He's got a strenuous job, carries and lifts and has to build stuff. So he had a medical marijuana card and everything was going fine. Then marijuana became legal. So he didn't feel the need to have a medical marijuana card. So the issue with him is that he'd rather use marijuana than be handed pain pills by a doctor. He does not want to take the pain pills. Marijuana works for him. It eases his issues. And that's all he was trying to address. And I would ask, we have, obviously this is statutory in terms of what you have to do, but with regards to the testing and the inpatient or outpatient stuff, I'm just asking to give him a chance to get his medical marijuana card if that's what you want, and to be able to smoke within the limits of that medical marijuana card rather than have to go to a doctor and get handed pain pills. And that's all, and he will comply with anything else that you ask. I might also add, Your Honor, with regards to this offense, if you can look at the police report, absolutely nothing wrong with his driving. They just simply stopped him because they smelled marijuana. That's all.
Thank you. Mr. Ring, is there something you'd like to say today, sir?
Just that, this is an old case. I thought it was behind me. I'm trying to move on with my life and become a better person. I'm not the same person I was 8 years ago. And since this instance, I have not had not 1 ounce of police contact other than doing work. I'm trying to be the best person I can be, and this case just, I'm at a loss for words. I mean, I thought it was behind me, and then I find out when I'm doing a job that I have a warrant for this that I knew nothing about. So, just, that's it.
All right, thank you. Well, these situations are tough when it's been a long time since the initial event happened, to try to figure out where a person really is with respect to, first of all, their understanding of what's right to do and what not to do. So as the court goes through this process, 8 years later, understanding that it got dismissed and it was reauthorized and you didn't know in the whole 9 yards, the court has no real contact with the defendant other than through their contact with the system. So that's how I try to figure out who you are, which makes it tough. Because in this particular circumstance, there is some resentment. I'm sure that you're still going through this some 8 years later. And it was compounded by the fact that you were going out of town and trying to cooperate, but yet rush through the process. And then we get here today and the probation agent, the prosecutor have concerns, which are rightly so, try to figure out whether or not you really understand the nature of the offense, whether it was 8 years ago or not, and whether or not you are still a danger to society. And I heard your attorney when he said there was no bad driving and it was just the burnt marijuana and now this is all legal. The thing that's still not legal is to drive while you're under the influence of marijuana. That is still an issue. And although that was 8 years ago and you didn't do it since this new law came into effect, the court wants to ensure that you fully understand that that would still be an issue today if the officer stopped you and had concerns. The question obviously would be whether or not the stop was legal and all that, but that's a separate issue. You've pled to this and now you're before the court on the issue of driving while you were under the influence of marijuana. So brings us to the request by your attorney, which is to give you an opportunity to continue to smoke marijuana. Because this technically, you didn't have an MMA, you didn't have a medical marijuana card, so it's not technically a violation of the MMA, because it was before the MMA. And if it was now, of course, it would be a violation of the MMA and the court wouldn't have to give you that opportunity. But that law wasn't in effect either. So I have to look at the cases from back then and figure out what's the best thing to do and what's in the best interest of the community. So having said that, for the most part, I'm going to follow the recommendation of the probation department. It is a sentence of this court. So there were two options here. So first of all, we need to address that, Mr. Nelson. The first option was that he have 360 days suspended plus 5 days of community service. The other option is to have 364 days suspended plus 30 days of community service. The distinction is that obviously, number one, he serves 4 days of jail because it's mandatory. There's mandatory jail time, or he must do the 30 days of community service. Which one are you requesting?
Obviously, Judge, he does not want the jail, and the 30 days is a minimum with statute for community service. So obviously, he would choose the latter.
Okay. Having said that, sir, it's the summons of this court that you served 365 days in the Washtenaw County Jail. Credit for the 1 day served. 364 days are suspended plus 30 days of community service. You are on probation for 12 months. You will be eligible to have this particular thing set as the particular case. This particular probation discharge after you completed half of that term. So you'll be eligible for discharge after 6 months. Fines and court costs in this particular case for a total of $825. Attend the MAD Victim Impact Panel within 45 days. And the reason I normally do 11:45, but this is an old case. And back then we were doing 8:45. So I'm giving the sentence that would have been given if this had been addressed about 8 years ago. I was a public defender back then, so I know how much the judges were actually.
Thank you, Judge. Appreciate that.
You attend the MAD Victim Impact Panel within 45 days of sentencing, provide a certificate of completion to the probation agent. Report to the probation officer monthly via the online reporting platform. So please make sure that you go online and report every month and report when and where directed as required by the probation, including our home visits. You must take the hard look at cannabis course with the first step referral. Contact them within 14 days to do so. There's no possession of alcohol, illegal drugs, paraphernalia, and no being in the presence of anyone using them. No use or possession of any firearm components, ammunition, or other dangerous weapon, and no being in the presence of anyone carrying or using those. You must drug and alcohol test. In this particular case, I am going to go with the 2 times per month, and that'll be. Have you been testing since you were before Judge Simpson?
No.
Has he been testing?
No.
No. I am going to do the drug and alcohol testing 2 times per month, and I'm going to do that for the first 60 days. I'll do a review in 60 days on November the 16th, 2023.
Can you do the 21st or 22nd if possible?
1 second. I think the 24th is Thanksgiving, so I don't think I'm going to do that.
No, I meant I said the 21st or 22nd.
21st. Okay.
Okay, that's good.
Wait 1 second. No, that's not. It's going to be on a Thursday. I could do November 30th.
Take a look. Can you do that late morning, Judge?
Does late mean 10 or 11?
11's good.
All right. Okay. All right, 11 a.m. Sir, given that this incident occurred before the MMA and it's not technically a violation of the MMA, with some documentation of your medical situation, the court will allow the medical marijuana if you get a card. Okay.
Thank you very much, Your Honor.
You're welcome. All right. You need to contact the probation department tomorrow after 9 o'clock to sign your probation contract, okay?
Problems. The two are married. She wants him back in the house, and she and I've had standoffs about whether or not this case was going to be dropped. I told her it wasn't. There's plenty of evidence to support the accusation that it's here. The happy medium is what the result is here, because after the arrest on the violation of the protective order, Mr. Burge has been in compliance since that date. I'm comfortable with the resolution, despite the fact that I can move forward with a felony, because of the findings that occur with a deferred adjudication on family violence. So as long as there is no more conduct, then hopefully Mr. Burge won't be put in a situation where somebody has to make more decisions about his life.
Yeah, what's his last name?
That is
trying to read y'all's right now.
That's about the contact that the two of them want to have.
Okay, what is it? Read it out in the record, please.
Go ahead. I believe it's worded, Judge, that upon request, the agreement is that that he be allowed to live in the household with Ms. Burge.
The way the probation conditioned to where he can have contact and live with the complaining witness, and the parties are married.
My preference is that he starts the BIP program and shows some progress in that before it occurs. But we both know that it's your honor's call on that, Judge.
And Mr. Ham will agree with me. The parties, including the complaining witness, want this behind them. They want to move back in together, and they have reconciled. They just can't live together right now.
That is a truthful statement.
How long was he in jail on this?
I don't recall that, Your Honor. I don't think it was any significant period of time in front of the judge. I know he had a follow-up jailing because of the protective order, but I think it's days. It doesn't even amount.
3 days.
Okay. 22-40978 is now called the State of Texas versus Trevor Dustin Burge. You, Mr. Burge?
Yes, sir.
With Mr. Reynolds, your attorney and the state's attorney, does the defendant waive a formal reading of the indictment and the arraignment here? Can we proceed in summary?
He does, you may, Jim.
In summary, this indictment alleges that on or about September 26, 2022 in Jefferson County, Texas, you committed the third-degree felony of assault, family violence by choking. Do you understand what you're charged with?
Yes, sir.
An agreement has been reached that you would be prosecuted for the lesser included Class A misdemeanor of assault, family violence. Is that your understanding of the agreement?
Yes, sir.
Which carries with it up to 1 year in the county jail and or a fine up to $4,000. Do you understand the punishment range applicable?
Yes, sir.
In this case, the agreement's further been reached where you would be pleading guilty, placed on 2 years deferred or unadjudicated probation, fined $500, and there will be terms and conditions of probation, which are normal and customary, including the Batterers Intervention Prevention Program class as a condition of probation. Is that your understanding of the plan?
Yes, sir.
If I follow this agreement, you have no right of appeal of your case. Do you understand?
I understand.
How do you plead to this lesser included Class A misdemeanor of assault family violence? In this case, guilty or not guilty?
Guilty.
Are you pleading guilty voluntarily? That is on your own free will and because you are guilty.
Yes, sir.
I show you what's marked as State's Exhibit 1. Did you sign that voluntarily? Did you understand it? Discuss it with your attorney? Or the contents all true and correct?
Yes, sir.
State's Exhibit 1 tendered into evidence.
No objections?
Without objection, it's admitted. Among other things, this states you are mentally competent to enter your guilty plea, which is freely and voluntarily made. You know what you've been charged with. The indictment's been read to you. You've read it. You were guilty of the crime charged in any lesser included offenses, such as this Class A misdemeanor assault you were pleading guilty to. You were giving up your rights to a jury trial and the right to the appearance, confrontation, cross-examination of witnesses, and you were totally satisfied with the representation provided by your lawyer. All of this is true, so help you God.
Yes, sir.
State's Exhibit 1 is made a part of the record for all purposes. Pre-sentence report, Wayne?
So Wayne.
If nothing further to add by any of the parties, I'm going to find that you, Trevor, Dustin Burge, are pleading guilty to this Class A misdemeanor of assault, family violence voluntarily. You're mentally competent to do so. You understand the consequences of pleading guilty. There's sufficient evidence supporting your guilty plea from State's Exhibit 1 admitted in this hearing to find you guilty beyond a reasonable doubt. However, I'm going to defer any finding of guilt and place you on deferred or unadjudicated probation for 2 years. You will be fined $500. There will be terms and conditions of probation, which are normal and customary for this type of case. You must complete successfully the Batterers Intervention Prevention Program. You understand what has happened today?
I do, Your Honor.
Well, this court gets to annotate a little bit on certain cases, but do y'all have children?
I have
Do you have children? Yes or no?
Yes, sir.
Okay. You and this lady?
Yes, sir.
Okay. How many?
There's 3. My second one has an adopting pending on today. An adoption. And I have a 2-year-old special needs and a 15-year-old stepbrother.
Okay. So what in the world were you up to on this event? Why would Mr. Family Man, and there you are, you're wearing the crucifix and you're wearing your little shirt, and that doesn't mean a thing to me. Actions is what speaks for me. Actions. This is the lady that you were ceremoniously married to. We had a ceremony and all that. Was it in church or a GP or something? Or
Mexico.
Did it count? Did it mean something to you? Oh, okay. So you pledge your love to this lady to become one, as the Bible that you must be familiar with would say.
Now,
then you have children. Oh, you just learned about the Bible since this event in last September?
I've learned a lot.
How old are you?
31.
Old enough to know better. You've been an adult for 14 years. Not necessarily acting like an adult, but you've been an adult.
Yes, sir.
But this is a person, number one, ladies are supposed to be treated with honor from the men. And it's quid pro quo, ladies also respect the man, but you are two people who are role modeling, and your children are going to do what are going to emulate your actions. And if you choke the mother, your wife, how are they going to live their life, learning in the household that this relationship is built upon choking? That's just terrible. It's terrible. You don't do that to anybody. It was told to me a long time ago, when you put your hands around somebody's throat and squeeze, your attempt is to kill them.
That's true.
Well, this is what you pleaded guilty to, sir.
I know. Wholeheartedly.
Well, you need to fix this. You need to live your life instead of in the way that you want to come in wearing a crucifix and a big shirt with some moral message to it. Carry your life out. Words don't make a difference. Wearing a jersey doesn't make a difference. It's how you play the game out in the field. Life is acting the part, not talking the part. You cross the line here. Don't let that happen. Certainly don't let it happen on my watch, because I'm kind of sensitive about familial respect. I've got children, grandchildren. I've been married for 43 years. And so I have come to appreciate how important a relationship is, and how it's important to the others who see your life and live their life, because you're an example setter for your children. And this is a poor example. This needs to get fixed. You fail on my watch, and you can imagine the consequences. Depending upon the circumstances, they could be severe. You can go to jail for a year. And in fact, right now, I could put you in jail as a condition of probation for 180 days. Which I think I've done in these kinds of cases in the past, in certain circumstances. So fix this, sir. There are a lot of people relying on you. And you're the head of the family. Act responsibly. Act like you're the role model. And then everything else seems to, for the most part, work just fine. But not acting that way when you are the role model fouls up the whole train. You're the engine. And if you run off the tracks, everything behind you falls to heck. So fix this. Okay. Anything else? No, sir. And you have an attorney here who I've known him for almost, since I was a youngster. A very good man. Good role model. Follow his advice. Anything else? Thank you. Thank you, buddy. See the probation officer, and she'll go over all those terms. You will sign, and you will begin probation. Do we have a